everyone, Attorney Adam Schmalzi here again at my office located at 47 Harvard Street in Worcester, Massachusetts. Today I'm going to explain the process of the dreaded arraignment. Now, a lot of people already know what an arraignment is, but I get a lot of calls from people who say that they've either been arrested or they received a summons from the court, they're scheduled for their first court appearance, and they don't know what to do. Nowadays, a lot of people, even if you've been arraigned in the past, don't know what to do because we're in the middle of a pandemic and things have changed. The courts have to move on. We've figured out ways to deal with it, and it usually comes in the form of a Zoom hearing or a teleconference hearing. Today I'm going to explain that process, hopefully give you some guidance, and maybe help you understand it better so that you're prepared for your arraignment if it unfortunately happens to you. So what is an arraignment? An arraignment is the defendant's first court appearance in the criminal court. The purpose of the arraignment is so that the court can formally read the charges to the defendant and allow them the opportunity to either plead guilty or not guilty. Most of the time, the court will automatically enter a plea of not guilty on behalf of the defendant, which will give them an opportunity to hire a lawyer or put together a strategy on their own to defend against those charges. How long can an arraignment take? Unfortunately, there is no good answer to this question. An arraignment itself should only take about 15 minutes. Most of the time, it's no longer than 5 or 6 minutes. But each and every clerk in every court has their own method on how to run that room as efficiently as possible. That means that your case could either be called first or sometimes, and unfortunately, last. That is why it is so important to be either on Zoom just before 9 a.m. or in the building and in your chair just before 9 a.m. so you don't miss your case when it is called. Once you hear your name, the court officer will ask you to stand up to the microphone so that the clerk can read you your charges. If your case is by Zoom, you need to make sure that your video is on and your audio is enabled. After that, the clerk will read your charges, and then the judge will enter your plea. Once the judge enters your plea, he or she will ask the prosecutor whether or not they have any requests for your release. If the prosecutor is seeking bail or some other type of condition, they will tell the court exactly the amount of bail they're looking for and exactly what condition they are seeking. To support their reasons, the prosecutor might read the facts directly off of the police report or look at a person's criminal record, history of defaults, violations of probation, and so on. What conditions might a prosecutor ask for? Well, first and foremost, the prosecutor might ask for some cash amount of bail. If no amount is requested, a person will be released on their promise to appear at the next court date. This is also known as personal recognizance, and it's followed by the bail warnings and the conditions of release if there are any. In addition to or in lieu of a cash bail, the prosecution might ask for the court to set some conditions of release. These are requirements set by the court that the defendant has to abide by during the pendency of that case. These could be conditions like GPS monitoring, random or scheduled drug or alcohol screening, conditions to report to probation on a regular basis. Either way, if these conditions are set and that person violates those conditions, a warrant will likely issue and that person will be brought to the court by the police. If the crime that you are charged with involves a gun or some inherently dangerous activity, the prosecution might ask for a dangerousness hearing under 58A, which could hold a person for up to 120 days without being able to post bail, but that is a topic for another discussion. Before the judge makes a decision, they'll ask the defendant to give their reasons why the prosecutor's request should be denied. In most cases, I would suggest having an attorney there to stand up for you to make a strong and compelling argument in your defense. A defense attorney will highlight a person's good characteristics and demonstrate to the court that the defendant is responsible enough to appear at court when they're supposed to and to refrain from committing any new offenses. If all goes well, that person will be released on their promise to appear with whatever conditions the judge imposes. At the end of the arraignment, a defendant will be given their bail warnings. Bail warnings are pretty straightforward. If a person commits any new offenses while that case is pending, their bail could be revoked and they could be held for up to 90 days without the opportunity of posting bail. So show up to your hearing, be on time, don't commit any new offenses, just stay out of trouble. You should be okay. After the arraignment, the court will schedule your case for a pretrial conference date somewhere in the future. You've officially been arraigned, your case has officially begun, and you can start putting together a strategy for your defense. Here are some tips for your arraignment. If your case is arraigned by Zoom, make sure that your microphone is off until your case is called. The court can hear everything going on behind your screen, so make sure you're muted. Tip 2. Dress nicely and keep your hands out of your pockets. I tell most of my clients to dress as if they are going to a formal event. You don't have to wear a tuxedo, but demonstrate to the court that you have respect for the system. This is your first impression with the court. Try to make it a good one. Tip 3. If you don't know where to stand, look to the court officer. They're there to help you. And in this state, they do a fantastic job. They will guide you. Tip 4. If you think, for whatever reason, that the prosecution is likely to ask for some amount of bail to be set, bring it with you and bring it in cash. If not, make sure that you have somebody close by who can post your bail if a bail is set. Be polite. Address the judge as Your Honor. Yes, Your Honor. No, Your Honor. Please, Your Honor. Thank you, Your Honor. If you have any questions about an arraignment or any of the steps in the process of a criminal case, email me directly at litigatema@gmail.com or call my office at 774-314-9124. Thank you.